evening. I'm your moderator, Valerie Osborne, for those who don't know me. I'd like to have you please first have the Pledge of Allegiance to the flag. Am I right?
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
I'd like to introduce the people at the head table here tonight. To my left is Town Clerk Ann Brody. Next to him is William Hewig, Town Council. In the corner, in the blue shirt, is Finance Director Greg LeBrick. I'm going in my order here. Yes, and then there it is. I knew I had a secret. And then we have the Board of Selectmen. If you would put your hand up, Donald Graney, Elizabeth Gorski, and our new selectman, Joseph Damore. Welcome, Mr. Damore. Let me see. That's it. We have a very short meeting tonight. Oh yes, finance. Have we got the finance? Yeah, I'm getting it together. Didn't come back to me. Okay, the finance. And who's the chair?
William Cook.
William Cook is the chair.
Wow.
Andy Wiles, John Gray, Michelle O'Keefe, Lee Berry, and Tom Minicello. Thank you everybody for serving the town. Town Clerk, would you like to start reading, please?
To Robert J. Kamelowitz, Chief of Police with the Town of Groveland and the County of Essex. In the name of the Commonwealth, you are hereby required to notify and warn the inhabitants of said town who are qualified to vote in the special town meeting to meet at the main meeting hall at Town Hall, 183 Main Street, on Monday, August 5th, 2013, at 7 p.m. to vote on the following articles.
Article 1. Now for this article, we have to have a 2/3 majority vote. Okay? Article 1, I'll read it. To see if the town will vote to raise, appropriate, or transfer from the stabilization fund or other available funds the sum of $600,000 for the purpose of settling a lawsuit against the town styled as, quote, City of Haverhill and Aggregate Industries Northeast Region Inc. Incorporated plaintiffs versus the Town of Groveland defendant. Essex County Superior Court Civil Action Number 2011 CV 00494, or take any other action thereto. Board of Selectmen recommend.
Favorable action.
Finance.
Favorable action.
Move favorable action.
Moved. Has it been seconded for favorable action?
Second.
Second. Discussion. Would someone like to explain what this article is about?
We're going to have town council explain this to everyone. Whether you know it or not, we've been involved in this lawsuit for probably 7 or 8 years.
Can you speak up?
Yep. One of our insurance companies, Fireman's Fund, has been defending us. They've probably already spent $500,000. Haverhill started out wanting near $5.5 million, but Bill Hewitt can explain the whole thing to you, and just so you don't think we're trying to hide it from everyone. It wasn't public notice to be put out there.
Madam Moderator, members of the Board of Selectmen, ladies and gentlemen, good evening. I'm stepping out of my normal role tonight as town council, but my usual role for town meetings is to be, as I see it, kind of a glorified referee. I don't take a position, a policy position on any of the warrant articles that are normally before you. So tonight, my role is a little different. I'm addressing you tonight in the role of an advocate, and I'm doing so with the permission of the selectmen because I'm one of the attorneys who has been involved in this lawsuit for about 7 years now. So I will come before you and give you the background, the history of the case, the history of the landfill. I'll describe for you the course of our negotiations, the litigation we've been involved in, what's been done, and how we arrived at the settlement posture we're in now, where there is a proposal to settle the case for $700,000. $100 will come from insurance companies, and I'll explain to you why that's so little, because it is. And $600 under the proposal, if you approve it tonight, would come from the town. And the finance director can tell you that it would be paid out of the stabilization fund, which there is sufficient money at present, and that would require a 2/3 vote on your part. I would be happy to answer any questions that any of you have, but let me go through my presentation for you first, so I can give you the complete picture and tell you why I've come before your selectmen, why I did that in May or June, with a recommendation that they accept this proposal, this settlement, and why I'm coming before you tonight, recommending the same and asking you to vote in favor of it. The Haverhill Municipal Landfill is a large landfill of about 55 acres in size, and it's located on Old Groveland Road in the east end of the city of Haverhill. It's been operated by the city of Haverhill as a municipal, commercial, and industrial landfill site, but beginning about 1935 and going up to approximately 1981, when municipal waste stopped going in, and when it was used entirely for sludge from the Haverhill waste treatment plant and some commercial and industrial waste, and then it was shut down in 1996. So the landfill itself operated from approximately 1935 until 1996. Groveland participated in the operation of the landfill between the years approximately of 1945 until 1974. And Groveland's participation was as follows. Beginning in 1945, the selectmen of Groveland had a contract, a written agreement, with the city of Haverhill that allowed residents of the town of Groveland to take their personal waste, their personal trash and garbage, drive it over themselves and put it into the landfill. And that was done. And there was an annual agreement between the city of Haverhill as the operator of the landfill and the selectmen of the town of Groveland. I shouldn't say annual. I think the agreements perhaps meant 5 years or 10 years. There were a succession of agreements, at least that stretched from 45 up to 74. And during that period of time, Haverhill residents themselves, I should say Groveland, well, Haverhill residents did too because it was their landfill, but Groveland residents were allowed to take their garbage over and dump it. Also, during those periods of time, because there was no municipal trash collection on the part of the town of Groveland, there were no Groveland garbage trucks going around picking with curbside pickup. But annually, for a certain period of time during those years, there was also a large trash collection pickup that was sponsored by the Board of Selectmen of Groveland, sponsored by the town, and which allowed people to put large trash items such as refrigerators, stoves, or those sorts of things out on the curb, and those items would be picked up by vehicles that I believe were owned by the DPW, and they were taken then, and that large trash was also deposited into the landfill. So Groveland's participation goes from approximately 1945 until the agreement with Haverhill was concluded in 1974, and from that point on, the town's waste has gone elsewhere. Now, the law, as it's been established by Congress about waste, hazardous waste, toxic waste, contaminants in the soil, by the regulations by the Environmental Protection Agency, case law established by courts all over the country, and also the Commonwealth of Massachusetts laws about pollution, putting contaminants into the ground, essentially will say that anyone will be liable for the costs of the cleanup and the closure of a landfill if they do one of three things. The first is if you operate a landfill in which contaminants are put in and contamination leaks or leaches down into the soil from what you put in the landfill. The second is if you transport waste into a landfill. And the third is if you generate waste that goes into a landfill. So under both the state and federal statutes, Groveland would probably have liability, and as your lawyer, I can tell you, it's my opinion, it does have liability for whatever amount of contaminants has leached or drained into the ground from the municipal waste that was deposited there by either residents or by the town during the large trash cleanup between the years of 1945 and 1974. So, as a lawyer, when you look at a case, you look at two issues. Is there liability? And if there is liability, how much are the damages going to be? Starting with liability, as your lawyer, and I've been involved in this case for about 7 years, I can tell you that we will be liable. The town will be liable. There's no doubt that residents in the town deposited waste. There's no doubt from the scientific reports that contaminants have leached down into the ground. And although we can't point to a particular amount of mercury or a particular amount of potassium or chlorine or other contaminants and say that came from a battery deposited by a Groveland resident, we can't do that. What the EPA has done is the EPA has prepared tables of studies of what percentages of contaminants are likely to have come from municipal solid waste, typical municipal solid waste that residents that we would all throw away over the years, which would include batteries and lights and neon lights and paint brushes and engine oil and things like that. The typical things probably all of us have thrown away. The EPA has come up with tables that you can look at and say, all right, if you can't prove that the potassium and the chlorine and the mercury and the other contaminants came from specific items that residents of Groveland deposited, we can say with reasonable certainty that over a long period of time, it is likely that X amount did come from municipal waste. And the numbers come from tables, and the tables come from volumes and periods of time, and those numbers are out there, and those numbers are calculable. And I've seen them. So liability is something that we have to accept. It's given. If the case were to go to trial, there's no doubt that we would have to pay something. The question is, because under federal and state law, the town was a generator. The residents were a generator. We put waste into the soil. The question then is how much? And for about 7 years, I have been involved along with Insurance Council in trying to get the city of Haverhill, who is an owner of part of the landfill site, and the other plaintiff, which is Aggregate Industries, that also happens to own part of the land, and therefore they're also a plaintiff, trying to get them, trying to negotiate them down to a point where the settlement number that they will accept was, in my opinion, my legal opinion, reasonably representative of the likelihood of liability and damages if you go to trial. I'll give you a little bit of history of the course of our negotiations and of some of the other things that have gone on over the last 7 years. I recognize that some of you have not heard of this case. It was initiated by a letter that the town received in December of the year 2006. That letter was sent to the town by Haverhill, City of Haverhill, and by Aggregates, and it simply said, we think you are liable for contaminants going into the ground because you were a contributor to the landfill between the years of 1945 and 1974. Under the EPA and the Massachusetts statutes, you will have liability and you will be required to pay damages, and here's our demand. The original demand that we got was $5 million. And of course, that's out of the question. The way that you start to approach a calculation of damages is to look at what the total cleanup costs will be, and then try and calculate some sort of multiple of the likelihood that the town will be found liable, and also something based on the volume of waste that was put in and the amount of contaminants leaked into the ground. And these are very technical matters, well beyond my ability or the ability of the insurance lawyer to calculate. As a result, the insurance company engaged an expert who was from Colorado, who was an environmental scientist, and was able to give us an evaluation. If you take the volume of waste that was put in 30 years by residents of Groveland, and these volumes are approximately known because we know about where it was put in, and you can calculate how much is there, and you can figure Groveland, in the contract between the town and Haverhill, Groveland said, we'll pay you 10% of your operating costs, City of Haverhill, to use your landfill. So it was thought, and probably reasonably so, that Groveland's contribution is about 1/10 of that of Haverhill. And that the reason for that number was because that was the approximate comparison. So if you take these numbers and you take the years and the volumes and you take the numbers that the EPA has, our expert came out and said, I think you would probably be, as a generator, if you applied the numbers, I think you'd probably be on the hook for somewhere around $500,000 or $600,000. And that was in 2008 dollars. So if you can, admittedly, there's been a recession, so construction prices and costs have not really gone up on a straight line over 4 or 5 years, but in the last couple of years they have started to go up. So if you take our experts' calculation of damages, which are about $500,000 or $600,000, but $560,000 2010 and $590,000 in 2012, $600,000. And then if you say that's going to be a judgment, the plaintiffs would be allowed to calculate in their own costs for expert fees, and they'd also be allowed an award of interest, which at the statutory rate is 12%. So 3 years since the lawsuit was started, 3 times 12, 36. You see how quickly that number goes up. Now you're talking about 800,000 or 900,000 and possibly more if you wait for a trial for 2 or 3 years. And that's our number. That's what our expert has said. Our expert's going to come in on the low end. Our expert is going to be our minimum. This is the argument we make to the jury. We're not liable for any more than this, but that's our side of the story. And if you're arguing in front of a judge and jury, the other side gets their chance too, and their expert's going to come in at who knows what. Anyway, let me go through with some of my additional points that I wanted to give to you. We have worked very, very hard on this defense. The first thing that we tried to do was identify an insurance policy that would pay both for the defense of the town and also for the indemnity. That means pay the attorney's fees and also pay a judgment or pay a settlement amount. Now recognize that you're talking about the years 1944 to 1974. And so the first thing we tried to do, as Nancy knows and the selectmen know, was we went back through the filing cabinets behind Nancy's office in the other end of this building, and we went through drawers and drawers and drawers of old letters, correspondence, trying to find insurance policies, and we could not find anything from the year 74, 45 to 74. Nothing. We went to Norwell Insurance Agency. We searched their files. We took their deposition. We reviewed all their correspondence, all their letters, all their documents. And what we learned was that Fireman's Fund was the company that wrote the insurance policy, but we didn't know how much the coverage was, and we didn't know that we didn't have a copy of the policy. So we wrote a letter to Fireman's Fund, and we demanded that they defend and indemnify the town. And the letter we got back said, we can't find any policies either. I have to confess, I was astonished that we do not require insurance companies to keep their policies, but we don't. But they said, we however know from similar policies, and there was a policy number. They said, we know from similar policies and from the form of the insurance policy that this policy number identifies that your liability cap was $5,000. And we found this for 1 year, and that year was 1971. So we have, we continue, this is about 5 years ago, we continued to try and locate that policy. There is an insurance library, there's the director, there's an insurance, the Office of Insurance Commissioner for the Commonwealth of Massachusetts. We tried the insurance commissioners in the state where Fireman's Fund is located, Illinois, California. We tried 12 ways to Sunday to find that insurance policy because it might have said a lot more than 5,000. We even hired a man named Henry Booth, who is a nationally and internationally recognized insurance archaeologist. He specializes in digging out insurance policies. Henry came up here, he spent about 3 days going through all our stuff. He tried all of the sources that he has available to him online, documents everywhere, and he couldn't find anything more from Fireman's Fund either. So there we were. We had Fireman's Fund that agreed to defend the town and to hire a lawyer, and they did. They hired a team of environmental lawyers from the law firm of Morrison, Mahoney, and Miller. And they said, we'll pay up to $5,000 in any judgment against you. We'll get more into their role in a second. Henry Booth did, however, uncover another insurance policy. And that was a policy issued by a company called Massachusetts Bonding and Insurance Company, and it was issued in the year 1955. And this had a policy of $25,000. There was no pollution exclusion. There was no pollution exclusion in the Fireman's Fund policy. Massachusetts Bonding Company is, however, out of business. But we determined after some research that their successor in interest is Hanover Insurance Company. They have a big office in Worcester. They have their headquarters. It's an international company. They're out of London. They have a big office in Atlanta. They had a local regional office in Worcester. So we wrote them a letter and said, here's a policy. We demand that you defend it and indemnify the town. So they came in and they said, well, you got a $25,000 policy. We'll give you $25,000. They came in very late in the game. And I'll put the two insurance companies all together in a moment. But what I want to tell you is that during the 7 years that this has been going on, there have only been 3 of them in which the lawsuit was filed. Lawsuit was filed in the year 2011. And Morrison, Mahoney, Miller came in, and somebody said they'd spent a lot of money defending the town. They have. They've spent over $500,000 in lawyers' fees defending the town. So I don't fault Fireman's Fund too much, because although they're not particularly generous on the indemnity part, they've been very generous on the defense part of the town. And a lot of what Morrison, Mahoney, Miller's lawyers did, I think, have been successful in bringing the price of settlement down, as well as what we have done too, because I've also been involved in the case because you have an uninsured exposure of liability above $5,000. But my fees have not been anywhere near $500,000. I've let Morrison, Mahoney, Miller do most of the work. The lawsuit commenced in 2011. We had any number of negotiating meetings, settlement meetings, discussions, phone conferences, meetings in big conference rooms over the last 2 or 3 years. The initial settlement demand was $5.5 million. We countered with $200,000. That was our first offer. Settlement demand eventually came down to $3.5 million. And I don't remember whether we went up to from 2 to 3, but you know, we were still pretty 250. Okay. Mr. Brady says 250. Settlement then came down, the plaintiff's demand came down to $1.5 million. And there it stayed for about 2 years. I did not think we were going to be able to get them down below 7 figures. There's often when you're negotiating with somebody else on any kind of a lawsuit, there's kind of a psychological barrier. There's going to be some number that they have to have, that they have to get, and it takes a lot of work to get them below that. And Wes Marshall, the Morrison, Mahoney, Miller lawyer, and I both thought that number was $1 million. So we were surprised when they came back this spring after 2 years of no movement. And they said, we'll accept $800,000 from you. At that time, I reported to the selectmen, and I had been saying to them, if we can get the plaintiffs down below a million, down to the $600,000, $700,000, $800,000 range, it might be a good idea to consider settling, because I think that's probably the best number we're gonna be able to get out of them. So with the $800,000 demand, I got to work on the insurance companies. And I got each insurance company to agree to contribute $50,000 additional dollars. So Fireman's Fund, even though their policy is $5,000, they're gonna put in $50,000. And Hanover, even though their policy was only $25,000, also agreed to put in $50,000 just to help us settle the case. So with that, I went back to the selectmen and I asked them whether they'd be willing to recommend $600,000. We would take the 50 from each insurance company, make it 7, and I would counter the settlement demand from the plaintiffs, the $800,000 settlement demand with $700,000 number, and tell them that's it. Not a penny more, nothing more. That's the best we can do. It's that or trial. And so I did that. I think it was about 2 weeks later they came back and said, we'll accept it. That's how we got to that number. Is that a good number? It's an inordinately huge number. And I'm very conscious, because I've been your town council and I've been to your town meetings and your selectmen meetings since 1991. I know how cautious, how prudent you are, how careful you are about wise spending of your money. So I can tell you that I do not come before you with a recommendation in that amount of money lightly. I would not recommend it to you if I did not think it was absolutely the lowest and the best number we're gonna get. And also, that if we say no to it, we will probably not have another opportunity to settle a case for this amount of money. So with that, I respectfully recommend to you, as I've done to the selectmen, that you vote in favor of $600,000 payment by the town, which will be joined by the $100,000 from the 2 insurance companies for a total of $700,000. That will put this lawsuit to bed. The closing costs of the lawsuit are now over $60 million. It doesn't take a lot of math to figure out how easy it would be for a jury to say, okay, Groveland, you know, 60 million, you could put in 2 or 3 million. I mean, juries are very unpredictable. There's no way to look at them, no way to know, even though you think you have a good case and you have good witnesses and you're well prepared. I can tell you from my own personal experience, you never know what a jury is gonna do. I've learned that the hard way, as has every lawyer who's litigated a case. So I come to you with some experience in these matters, but also with a great deal of respect for the way in which I think this town meeting is always very, very cautious and very circumspect in the way it spends money. I know your history. I know what this will do to you, because it is a big chunk. But I would also say to you that I think this is the best possible settlement you can get in this case. That's my legal opinion, and I would recommend that you consider voting for it. And I'd be happy to answer any questions that any of you have. Thank you.
Any questions? Thank you, Mr. Hewitt. Okay. Would you like to stand up and state your name?
Fred Hall, Broad Street. What is the balance in our stabilization fund?
I knew someone would ask that. I wrote it down for one line. After the little bit we spent at the annual town meeting for the police car and the South Groveland Fire Station, our current balance is $1,139,400.
Thank you. Well,
Any other questions?
Yep, Nancy Webster, King Street. Does this shut the door on any future liability related to this site?
Absolutely. We will sign a settlement agreement that will say we will have no further liability whatsoever for anything relating to this landfill from now until the end of the world. And it actually uses that language, from now until the end of the world.
plans to recover methane or other gases from this that can be used? I have a son-in-law that down in South Carolina, he's working on a project to recover gases, and he's running a pipeline over to a business. The Germans somehow are involved, but supposedly they're making money off of the landfill. Now, can that be done here?
That's an excellent question, and I have to confess that has not been raised in any of our discussions. It's very possible it could be done. But I don't think that the town of Groveland would be in a position to negotiate any part of that if we're paying $600,000 and the total closure costs are 40 to 50 million. So I say if Haverhill and aggregates can go make money with methane, let them go do it. But it hasn't been discussed.
Kevin Coniff, 7 Star Road. What's our liability on our trash today? Where our trash goes, is somebody gonna come back 50 years from now saying you contaminated something else and you owe money, or?
Good question.
That is an excellent question, and I'm gonna have to defer that until, until a further discussion about where we do now. You know, I think that it's a really good idea to start thinking in those terms. And if the selectmen would like me to look into that and come with some, you know, up with some
We
kind
don't
of
want to spend any
evaluation.
more money or anything, you know?
No, and certainly not tonight. But that's an excellent question. That's a really excellent question. I think we all should start thinking about that, because obviously this kind of thing can come back and bite you 30 or 40 years.
Sure, the people that threw their stuff in there never thought for a second that it was ever gonna come back out of there.
None of us ever did. We all did that. We all threw batteries out and paint cans,
We
you
do
know,
the same
and
thing
none of
today.
us.
Right now, our current vendor is Hiltz. His contract requires him to bring it to a state and federally licensed disposal facility, which they do, and our stuff is incinerated in Haverhill. So it doesn't go, if it goes into a landfill, it goes in as ash. So, but they fire an insurance binder with me every year. We have regular insurance policies now that I know where they are. And he's required to keep a bond available for all those years, and he, every year, on July 1st, in that first week of July, I will get a new bond from him, indemnifying us up to $5 million.
The gentleman with the hand up over here.
Do we have any plans to replenish the stabilization fund?
The stabilization fund has been built up pretty much over the last decade. What we do is, any money that's left over in the budget in the prior year, when it's certified by the state, we'll look at our capital planning needs, and other than that, we will put it back into the stabilization fund. The state recommends that we should try to keep about 10% of our, what we call our omnibus, our annual operating budget, available in the stabilization account. Thankfully, we had that going into this, so we don't have to ask for a tax increase or a debt exclusion or borrow the money to pay this off. But in my mind, obviously it'll be up to town meeting, the finance committee, the selectmen, I would prefer to begin building it back up again, yes.
Any other questions before we have a vote? There being none, we will take a vote on this. Remember, we need a 2/3 vote for this to pass. I'm going to just do an oral one, just voice votes to begin with. If it's close, we'll take a hand count vote. Those in favour of Article 1, say aye.
Aye.
Any opposed, say no. A unanimous vote. Thank you, folks.
Thank you.
And thank you, Mr. Hewitt.
Thank you, town meeting members.
Article 2, to see if the town will vote to transfer $20,000 from Police Secretary line item 10012105111201 to Police Office Police Other Wages line item 10012105111301 in order to fund additional patrol shifts as needed or take any other action relative thereto. Selectmen recommend.
Favorable action.
Finance.
Favorable action?
Move favorable action.
Is there a second for that? Second for favourable action. Any discussion on this?
I did see the chief here earlier. Maybe he could just explain it.
Is the chief there? Could you, yourself first.
Chief Kamilowicz from the Police Department. If anyone has any questions about the article, I'm happy to answer them.
Could you just give them a quick rundown of what the purpose is to spend the money, just so they'll know?
Okay, well, what we decided to do was actually think out of the box. And with, lack of funding for sufficient police patrols, we're one full-time officer short. We have been for years. So what I've decided to do is, instead of having a secretary to manage all the paperwork and the daily operations of filing, preparing the payroll every couple weeks, myself, Deputy Gillen, and Sergeant McDonald have absorbed all those duties, and we want to use that money to put more police officers on the street. Our call intake steadily increases every year, approximately 10%. And this way here, we can take that money and fill shifts with reserve officers. We can't adequately deal with the traffic complaints that we have because the officers are so busy answering calls. So this would put more officers out there to deal with traffic problems. And it's budget neutral. The other savings to the town is, if we have a secretary, that person is entitled to health insurance, excuse me, which is, Greg can tell better, but $15,000 approximately.
It depends if it's single family, but can anywhere from 5 to 15, yes.
So it's a cost savings to the town, remains budget neutral, and there's more officers on the street.
Any other questions?
Are any of the officers that are gonna take over the additional paperwork and secretarial responsibilities, are they coming off the street and off the road in order to come back to the police station to do that work?
There will be times, yes.
Doesn't that, I'm just looking for the logic of it.
Right.
Doesn't that seem to be counterproductive?
Well, myself and the deputy are in quite a bit during the day, and we're in there anyway, and now it's just increasing our workload. But I'm not on patrol myself, and I've increased my workload to do this. So it's a sacrifice for us. We have to take on more work, but I think in the name of public safety, it's a win-win.
Any other questions?
Move the question.
Move the question. We shall now move the question. We do not need a 2/3 vote for this one, so we'll vote on this. Those in favour of Article 2 say aye.
Aye.
Any opposed say no. Unanimous. Thank you. I would. Thank you very much, Chief.
To dissolve special town meeting.
Second.
Moved and seconded. All in favour of dissolving this meeting say aye.
Aye. Choose.
Oh yes, please, folks.
Here on 99.5